Hi, I'm Jody Sanders, and we're here as part of the Oral History Project to take the various oral histories of the former Second Court of Appeals justices. And I'm joined by former justice of that court, David Keltner, who's now a partner at Kelly Hart and Hallman here in Fort Worth. So let's go ahead and get started. David, thank you for joining us.
Oh, thank you.
Being interviewed for part of this project. Why don't you tell us a little bit about your background, where you grew up?
I grew up in Fort Worth and spent a lot of time actually down in Cleburne. I lived with my grandparents for a period of time due to my mother's illness, but primarily in Fort Worth. Went to Paschal High School and then on to Trinity University for undergraduate school, and got a BA in journalism, and then the Army thought they needed me, and so I joined the Army and was in the Army for a period of time before going to law school. Then in law school, I went to SMU. Interesting thing is, when I got out of the Army, it was in the second week of September, and law schools had already been going on for a period of time. And so I went to all the law schools for which I had been accepted before and asked whether I could get in. And evidently SMU needed the money because they let me join our law school class 3 weeks late, which probably wasn't the best thing I ever did. And my first year grades certainly showed that. But then went to SMU again, graduated from SMU in 1975.
One of the questions that I think they like to ask: how did you find out that you passed the bar exam?
Well, it was an interesting deal. I was in a trial with Bill Bowers, and I was very lucky because when I showed up to Shannon Gracie, I got assigned to Bill, and for a period of the first, I think, 8 weeks I was there, we were in trial 7 weeks, and it was great. And the bar results came out in early October, and I got a call from a friend of mine that said that he had received his bar results and they were out. And unlike where you could look it on the internet, then you either had to have a friend who was a briefing attorney at the Supreme Court and call them, or get someone to go look in Austin. But sure enough, I ran to the mailroom and at about 8:15 found an envelope, and it was obviously from Supreme Court. So I thought, this is it. So I opened it, and what happens is they cut out little strips that said what your grade was. And then the letter said the passing grade is 75 for those of you who passed the swearing-in ceremonies will be at Austin at this point. Well, when I opened it, the little slip of paper fell out, and I couldn't know what my grade was. And I looked down, and I distinctively saw 58, which is far below 75. And I thought, oh, my God. And I turned it around, it was an 85. So everything was good, and I had passed. That's how I found out.
Okay. So what did you do? You mentioned Shannon Gracie. When you got out of law school, where'd you go?
When I got out of law school, I got out at the normal time in May, and I had a fellowship with a firm in London during the summer and into the winter. So I went there for that period of time, then came back to Shannon Gracie and started. And it was a really, and I was there till I went on the Court of Appeals. It was a great time, and got to try a lot of lawsuits as a young lawyer, and realized I was more suited for appellate law than trying lawsuits. So that was a great start.
What made you want to become a lawyer?
My father. My father was a remarkable man and a really, really wonderful lawyer. He practiced in Fort Worth and had his own firm, Hudson Keltner, Smith and Cunningham. And Dad had a storied career. He was one of the people who started Alcon Laboratories, and he had a great story. Alcon's now a huge company that is owned by Nestle's, but it was publicly traded on the on the New York Stock Exchange for years. And Dad always told this funny story that they knew when it was time to have a board of directors meetings at Alcon, and it was when they could scrape enough money that Bob Alexander and Bill Connor and Dad could have lunch at Cattleman's. And that's when they had them. But he represented them, the Texas American Bank shares, and a number of other things. And he just was a remarkable guy. He had been very active in State Bar and the Tarrant County Bar Association, and very well respected, very, very well respected man. And I wanted to be like my dad. So that's what got me into law school. And the fascinating thing about it was I started late. Things were more difficult as a result of that. And then we got into the second semester, first year, into moot court. And in 2 weeks, I realized this was what I was supposed to do. I absolutely loved that, and the appellate courtrooms and briefing and fitting things into the fabric of the law was something I knew I wanted to do.
How did you find your way into appeals at Shannon Gracie?
Well, it was a fascinating story, and it was sort of interesting. We had a lawyer by the name of Gene Dozier, fabulous lawyer, who had clerked for the Texas Supreme Court, and Gene did all the appellate work, Jody. He was very, very good at it and was a brilliant researcher and also practical. Gene left to go to an in-house practice, and that left nobody. Kleber Miller, my mentor, I said, Kleber, I'd like to do that. And he said, no, you can't. And he said, you can't because appellate lawyers have no personality. And he pointed out to a couple, and he had a point. Nonetheless, I went around to all the lawyers, sort of behind Kleber's back, actually, and asked them to let me handle the appellate matters they had. And it was almost like I hung out a shingle that said David Keltner, appellate lawyer, and before anybody knew I wasn't, I was. And so Gene's leaving gave me an opportunity, and I started handling appeals, and very quickly got an argument, fortunately for me, in the Texas Supreme Court, and it was a good thing.
Any particular cases you handled at Shannon Gracie? Any appeals that were significant to you?
Well, the first case in the Texas Supreme Court, I got whipped. A 9-0 against me. I got the other side got petition granted and just killed me. It was on a number of unique cases, some business cases and the like. The one that stands out to me had nothing to do with business or trial. I got appointed. The Fifth Circuit at that time had a program in which they would use volunteer lawyers in criminal matters in cases they thought would be significant and might have a chance to go on. And in the 82-83 time period, the United States Supreme Court changed the laws on criminal confessions and what was a good confession and not. And Tom G. at the Fifth Circuit, then a judge, called and asked if I would handle a case in which there had been 7 confessions, and the basis of the appeal would be that. And I accepted it, and it actually a hilarious telephone call. He said, my briefing attorney will call you, and instead a staff lawyer called, and I said, well, this is great. When's the brief due? And he said, well, next week, but we're going to grant you a 30-day extension. And then they granted several more. But then I asked, well, can you send, here's our number, overnight the file if you can. And he said, oh, no, foolish man. He said, it's much larger than that. And 3 days later, a GSA truck pulled up. And it turned out the trial had lasted for weeks, and there were all kinds of exhibits and horrible things like that. And it was Webb versus United States. We were able to take out 6 of the confessions, and he was retried. That was a very tough oral argument because the allegations against him were that he had killed his own son and buried him, perhaps alive, on a federal reservation, and he had gotten a life sentence. And that case eventually went to the Supreme Court. The United States Supreme Court decided a companion case rather than that case, but it got me into the Supreme Court for the first time.
So were you able to argue that case?
We did argue it, but didn't get an opinion, and my luck in that result would continue for a while, but nonetheless, it was a joy to do that. That happened in '84, actually right before I went on the Court of Appeals.
Well, let's talk about that a little bit. What made you decide that you wanted to be a judge?
Well, I had wanted to be a judge for a long time, and I realized that my talents were probably, such as they were, I could do less harm at the appellate court maybe than at the trial court. And but there weren't any really going to be openings on the court. The court had expanded from 3 judges, then to I think 4, and then finally to 7. And Walter Jordan, a distinguished jurist who had been the judge of the 48th District Court before going on the Court of Appeals, had decided to resign. And he was kind enough to call me and tell me that, and suggested that there would have to be an election. He was up for election. No, he wasn't up for election, but there would have to be a election under the election laws. And the governor had indicated he would not appoint that close to an election. So with 5 weeks before the election left, in the Democratic primary, I ran. And Jody was a great deal. A lot has been said about partisan and nonpartisan election of judges. I will say this, that running for election is an humbling experience that brings you face to face with the people that you serve, and it is an experience that everybody should have. In any event, I was very lucky. There were about 7 people who originally signed up to run. They all dropped out, thank God, which made my election early, except one, who was the chief staff attorney of the court, Fred Fick, great guy. And Fred eventually withdrew too, but he withdrew after the ballots had been printed, so his name was still on the ballot. And at that point, if I was going to lose to someone who had withdrawn, I was going to have to leave the state. So in any event, luckily I lucked out and got on the court. And then Mark White was then the governor and appointed me to, I didn't have a Republican opponent in the general election, so he appointed me, and I took office September 1.
Of what year?
86.
Okay. Who was on the court at that time?
I was afraid you were going to ask me that. The court had transitioned a little bit with a number of appointments. Howard Fender was the Chief Justice. W.A. Hughes from Decatur, it was just rotating off the court. Judge Ashworth had just rotated off the court. Harry Hopkins from Weatherford was on the court. Bill Burdock had been elected by that time. Joe Spurlock, who teaches here at A&M, was on the court. David Ferris had gone on. We'd run in the same election. But David could take the bench before I did, and I think he took it in June or July. I'm trying to think, who am I missing? John Hill, of course, who had been a trial judge, both county court at law and district court judge before he went on the court. And those were the ones that were on the court. I think I may be short one, but I can't think who I'm missing.
So it was a 7-member court when you got on?
7-member court when I got on. And everybody was very nice to me when I got there.
Where were your offices at that time?
We were in the old Granite Courthouse at the end of Main Street. They were really magnificent. That courthouse had been redone, absolutely gorgeous as it still is. And while our chambers and offices were small, they were very nice. And we were on the 4th floor, very small courtroom, but again, very, very well appointed. And all the judges' offices opened onto a library area. So there was a lot of give and take between the judges. And David Ferris and I had been good friends before that and became very, very close friends while I was on the court. His and my offices were right next together. And there are rumors that we were cut-ups while we were there. And that is true. And I think Judge Ferris and his tape talked about those.
The statutes of limitations have probably run at this point.
What happened is there's a lot of downtime. Being on an appellate court is a monastic experience. You don't see anybody else except people that work there. I had grown up where my friends were lawyers. I dealt with lawyers all during the day. When we socialized, I socialized with lawyers. My wife's a lawyer, and we'll talk about that in a minute. We met before the Court of Appeals, but She was working there when I convinced her to marry me. But everything that I was doing had to do with the legal profession. I've been very active in the Bar Association, and all of a sudden you're cut off from those people, and you can't talk about the work you're doing. So you form fast friendships with people around, and to liven things up, David, I actually started it. I got water guns. And I left one on his desk that was full of water and said, "Let the games begin at 3 o'clock." And we chased each other throughout the chamber, shooting each other with water guns when we least expected. And we sabotaged each other's desks and things like that. And it was a fun time until Farrah shot Howard Fender with a water gun in the face as he walked in the door, and that did not go over real well.
How was the court set up at the time? Did you have staff attorneys, law clerks?
There were less staff attorneys then than there are currently, and that had a lot to do with budgets. But we had, as my recollection is, we had 3 permanent staff attorneys. We had a chief staff attorney, 2 assistants, and then every judge had a recent law clerk, a recent law school graduate as a clerk. For the most part, the permanent staff worked on mandamus, other emergency motions, and things like that, and also did heavy edits of the briefs, thank goodness, before they went out.
How were cases assigned back then?
We did it on a completely random basis, and Fort Worth has always been a little bit different in that, but some of the other courts wait till after argument to assign cases. We did not. There was a random pick of panels that would sit throughout the year. So there would be 2 panels of 3 sitting at any one time, an A and a B panel, and the remaining justice would be the administrative judge handling those matters. Some courts make the chief justice that. We didn't. It was a rotating deal. Cases were assigned. You got them about a month and a half before the oral argument to be able to take a look at them. And they were assigned to a specific judge as the author. Sometimes, in some cases, we would have pre-argument conferences. We had conferences after the arguments, discuss the cases, and then the judge assigned to write them would do that, circulate them, and see if we picked up dissents. Then they circulated to non-panel as well.
What surprised you when you took the bench after being an appellate advocate on the other side of the aisle?
Jody, I always thought I had a good idea about what judges thought. I did not have the first clue. And you hear this from all judges when you talk. It is important to great trial lawyers, for example, are great trial lawyers because they reduce everything to their lowest common denominator. And in that way, they convince jurors to do the right thing by getting it down to a simple decision. Good appellate lawyers do the same thing if you do your job right. Simplify the issue, state what it is, give a reason why you should win. But most importantly, this is what I think people forget, is you've got to fit everything into the fabric of the law. An appellate court justice is not just writing for that case and who wins or loses. It's not just balls and strikes. It's how the decision in this case fits in with other reported cases. I saw glimpses of that as a practitioner, but never understood how important those things were. So when you go in and argue a case, it was very important for me to say, and I would ask advocates this, how do I justify ruling for you with these 2 other cases? Explain how I can meld those together. And I think that was something I did not understand.
What are some of the cases that were important to you or you think important to the law while you were on the court?
Well, we had a number. I'll mention one by name. The rest of them, I'll talk about the issues so as to protect the guilty. One case that was, Texas was undergoing a horrible time with discovery, and there was an independent insulating glass case that came up in mandamus. And I sort of thought that discovery's idea was to seek the truth, and other than privileged information, everything that had a degree of relevance, close degree of relevance, ought to be discoverable. But the burdens weren't well set. So in independent insulating glass, I tried to refine that. Fortunately for me, a lot of other judges agreed, and it was very well cited for a period of time. The Supreme Court used that decision in setting the burdens of people making objections, and also burdens on people requesting to keep it relevant, and it made it into the rules. Now, I don't know that independent insulating glass, though, would be decided the same way today, but that was a great case. We had a couple of constitutional issues that came up. Batson was decided during the time I was on the Court of Appeals, or right before. That's the case that talks about the right to a jury, and that a racial minority or religious minority has a right to the same panel of his peers that everyone would. And so indiscriminate striking of people that look or have the same beliefs as the especially criminal defendant ought not to be tolerated. We had one, a very difficult case, tried by the Tarrant County DA's office, and I am absolutely convinced to this day that the lawyer who picked the jury for the DA's office did not mean to discriminate. Nonetheless, the practical effect of what happened resulted in discrimination, and we reversed. And there were all kinds of vitriol over the case. Reversed a case, and it was subsequently retried. The man was convicted again, but the truth of the matter is, I think the system was fair. That was at a time that there weren't many Batson reversals, and it was. We took a lot of heat for that, and we had people in the DA's office threatening to run against members of the court. I was the author of the opinion. In the end, everything worked out well and things calmed down. We had another case dealing with a statute passed by the legislature that would protect victims of rape from virtually testifying in the trial. That obviously had a problem with the right to confrontation, right to cross-examination, but that had been a huge topic in the legislature, and we took a lot of heat. I think Judge Ferris wrote that opinion, did a very, very nice job. I wrote my recollection is I wrote a concurring opinion to try to protect him in that regard. But, and actually, again, case was retried. The defendant was convicted again, but I think we could be more sure that it was a good conviction.
Any cases that got reversed by the Supreme Court or the Court of Criminal Appeals that surprised you, or you thought maybe they got it right and you got it wrong?
I got reversed by the Supreme Court on one case, and the big question was what the Supreme Court had meant in a previous decision. And there was only one decision on this issue that raised it. I ventured, the Supreme Court had not answered the question. I ventured to guess. But in the opinion said, if I am wrong, then the Supreme Court need not to reconsider, send it back to us, because the result would be would be an affirmance, period and paragraph. And in fact, the lawyer who I decided against called me after everything was over, and he said, I thought you were telling me to take that to the Supreme Court, so I did. And I was saying that. But Oscar Mozzie wrote the opinion, and Justice Mozzie and I knew each other. And in the opinion, he put in, the answer to this question is obvious. We decided in X case. The answer is X. The Court of Appeals justice who wrote the opinion acknowledged that and even predicted what our ruling would be when we overruled his ruling. And I called Mozzie, and he said, "Oh, we were having fun with you." But it's still out there, still sort of upset me.
Any other funny or memorable stories from your time on the bench that you feel like you can share publicly?
There are a lot of them. Well, first off, Larissa, my wife, was a briefing attorney for Judge Hopkins on the Court of Appeals, and we had dated each other before, and I finally convinced her to marry me while we were on the court, and she that course cost her a job. In any event, that was sort of a fun time. It was a very collegial court. And even when we disagreed, people were smiling and discussing things. And it was a great group of people. I very much enjoyed my time there.
Did you like being a judge?
Yeah. Listen, here's what I would tell everybody listening to this: if you like the law, you got to love being a judge. It's a great thing. What I will say this though. Partisan election of judges is a difficult deal in the political environment, which was changing during the time I was on the court. When I initially went on, we had 100% Democrats. There was a split among Democrats, Republican and more liberal. The Republican Party was gathering steam. In fact, Mark White, who appointed me, went off or lost an election, or didn't lose the election, but Bill Clements won the next election. That was sort of an interesting time in Texas politics. Republicans started running for the court. Chief Justice Fender was beat by Todd Weaver, who was another excellent Chief Justice, by the way, and somebody that was a great benefit to the court, as was Judge Fender. Larry Myers came onto the court very early, and then everyone on the court who ran for re-election as a Democrat was defeated. Judge Ferris, Judge Hill, who eventually became Chief Justice as well. But that was a difficult thing because there were very good legal minds on that court. By the way, the wonderful thing about the Fort Worth court was they were replaced by very good legal minds as well. But dabbling in partisan politics and not being able to have an opinion you could express was a difficult thing to do. And the money in the races got to me. I realized that if I stayed in that, I would be asked, I'd have my hands out for money for the rest of my career. And we have very good judges and do that with no problems whatsoever. For me, that was an issue. So I thought it best that if I wasn't going to do that and if I was going to run for re-election, I wouldn't change parties. I didn't think that was seemly either, that the best thing to do was relieve my friends of the obligation of giving me money to support me for. So I resigned.
What was the most rewarding thing about being a judge during your time there?
You know, I'm going to refer to Justice Scalia on this. Justice Scalia famously wrote that if you do your job right, and you are true to principles of stare decisis and of the rule of law, that you will make decisions that you are not happy with. And that certainly was true with me. But the discipline of writing within parameters and writing to put things in the fabric of the law was something I very much enjoyed. And it was a joy to watch things like that develop. That was just a ball. That was a lot of fun. And that's something you don't get to do really outside being a judge.
What do you think the most challenging aspect of being on the court was?
Two things. For me, there was a social impact, and the social impact was all my friends were lawyers. I couldn't discuss what I was doing. If they were discussing their cases, I would have to step away from the conversation. I was not prepared for that. I should have been, but I wasn't. But the other thing was the political aspect to it. During the periods of time in the 80s, things were radically changing, and they were changing quickly. and people had very hostile views towards different parties, and they wanted to know, were you on this side or that side? Well, in a political debate, really, if it's something that will come before the court, judge can't afford to be on either side. That was a very difficult situation. It's one that, thank God, really wonderfully great judges have been able to maneuver and do well. That maybe impacted me more than it does most judges.
So when did you leave the court?
I left the court in 1990.
And what did you do after that?
When I left the court, I went with the Haynes & Boone law firm in their Fort Worth office, although I spent a lot of time. We opened a Houston office during that period of time. I spent some time down there as well, and practiced appellate law, and we put together an appellate section, and it continues to do well to this day, without me, by the way. But it does very, very, very nice job.
And then what about after Haynes & Boone?
After Haynes & Boone, I worked there for 8 or 9 years, and some friends that I had been at Shannon Gracie with, John Jost, Mike Henry, and Ricky Brantley, had a law firm, and we were all very, very close friends. And I realized that if I was going to ever have a chance to go small, this would be it. And we practiced law together for 9 years. It was a great experience, and those 3 guys were honest as the day is long, most ethical people in the world. We were involved in a lot of significant trials, and I did the appellate work for, and it was an awful lot of fun. During that period of time, there was a huge amount of professional malpractice suits against lawyers. I was lucky enough to represent some of the largest firms in the state, and in that regard, and Enron and other matters. So that we had a great time together.
And then where'd you go after?
After that, I went to Kelly Hart & Hallman, where I am now. I've been there for a period of time. Actually, when I joined Kelly Hart, I actually was about to go to trial in a case with Bob Grable, who was one of the partners that had been at Kelly Hart from almost the founding of it. So I was walled off and had the Keltner law firm, which was just me, and did that for about almost 2 years.
Literally walled off. They had you in your own little separate office. Literally
walled off. Stacey Blanchett, my longtime legal assistant, who, by the way, Stacey, if you ever see this, I know that you're the reason everything works. And you know that too, Jerry.
That's very true.
But in any event, did that, and then I have been with I've been with Kelly Hart for now 10 years. So the 2 years I really wasn't, but I was around Kelly Hart. But then 10 years I've been with Kelly Hart, and it's been a wonderful ride. I very much enjoyed that.
I know you've handled a lot of significant cases since you left the bench, but what are some of the ones that kind of stand out to you?
Well, I represented Vincent Elkins in the Enron case, which was remarkable. There have been a whole bunch of others. One of the ones that I remember most is the Miller case, which I lost, by the way, at the Texas Supreme Court, which was a case regarding a baby that was resuscitated at birth, contrary to the parents' instructions. The resuscitation caused all kinds of horrible disabilities for Sidney Miller. And this was a suit that was basically over whether she would be protected because of the unwanted resuscitation for the remainder of her life, because she is not only not able to care for herself, but is really in bad shape. And it was a case that got a lot of controversy from various people. At that point, Rick Scott, that was the current governor of Florida, was the CEO of HCA, which was the defendant. They had insisted on the resuscitation, even though medical doctors had told the parents not to resuscitate, to give the child a chance to live on her own, but the resuscitation would cause problems. That was a huge battle that lasted for about 4.5, 5 years. The Supreme Court kept the case for 2 years before deciding it. It was something in which we were making a difference for the family. In the end, it didn't work out well, but I put my heart and soul in that case and really cared about that. There have been a whole bunch of other great cases I handled that I think made a difference to Texas law. We sort of, in the Hyundai case, redefined how the parameters of challenges for cause, I've been very lucky in that regard. And the other part that's sort of interesting is during all this period of time, I was lucky to be involved in the State Bar of Texas, and was fortunate enough to serve as chair of the board of the State Bar, which was a great thing, and helped build up the CLE department of the bar, which gives legal education training to Texas lawyers to make them more efficient and better lawyers to serve Texans. And I think that's something we all ought to try to do.
You've done some work for the Unauthorized Practice of Law Committee, too.
I did. Oh, I was hoping you wouldn't mention that. I handled another case, another loss, by the way, but I'm very proud of it nonetheless, and it wasn't a complete loss. For a period of time, insurers started having in-house departments that would represent their insureds in third-party cases. Unfortunately, and there's nothing ethically or morally wrong with that. The only problem is that in some instances, those lawyers, through conversations with the insureds, who is their client, learn things that might defeat coverage. And so you can have very big conflicts of interest. The Unauthorized Practice of Law Committee had gotten a ruling that in-house departments overall violated the disciplinary codes. That issue, I was asked to take that issue to the Supreme Court. We termed it differently to the court. We just said, the Unauthorized Practice of Law Committee is seeking guidance from the court about whether having in-house lawyers representing insureds in third-party cases is unethical, but that's a decision for the court. Most importantly, though, we are concerned about the protections that would have to be installed to protect the client insureds. And the Supreme Court decided it was ethical to have them, but set up a very precise group of guidelines that limited what those people could do because of the potential conflict of interest. And that took a long time, a lot of hours, and of course, just like the Webb case, it was pro bono. But again, I'm very proud of it because I think we made that system better and safer for Texans.
You've had a lot of different things that you've done in your career. Who have been some of the people that have been your significant mentors?
Well, first, Cleburne Miller. I mean, Cleburne Miller is about the best there was. He's one of the best trial lawyers I've ever seen. I always say this is, Cleburne Miller taught me everything I know, but not everything he knows. And that is absolutely true. I was very lucky to work with Bill Bowers in those first days, and Bill's sense of ethics, honesty, fairness really stuck with me. George Bramlett, God rest his soul, was a wonderful mentor at Haynes and Boone, and a very, very close friend, and was just a fine lawyer. And if I modeled myself after those two people, I'd be doing great. But then I got to practice with D. Kelly, and he was a force of nature. He was really one of my remarkable things. I have to tell one funny story about D before we end, but D was the most loyal human being I've ever met. He designed his whole practice to protect and represent a rather finite group of clients, which he did remarkably well. if you had D. Kelly as a lawyer, you did not need anybody else. He worked tirelessly. He taught me the value of loyalty, and his clients were absolutely loyal to him. Really, truly remarkable guy. I've been very lucky. The best thing that happened during the time I've been a lawyer is the increasing number of women in the profession. My law school class had 254, of which 16 were women. Now we're at parity of roughly 50-50 in law schools. Sharon Malyans, who works with Kelly Hart and our real estate section, both bought and sold the Plaza Hotel, sold it to Donald Trump on behalf of one of the firm's clients, worked on major real estate matters. Mary Ann Auld, who you and I both work with, is as fine an appellate lawyer as you can imagine. Nina Cortell at Haynes & Boone is one of the just consummate professionals that we have. So that's it. Now, I mentioned D.
Yeah, let's hear your story.
D could be challenging to work with. Right before I came with the firm, there was a dispute between the cities of Dallas and Fort Worth over DFW Airport and whether or not Dallas could open another airport or expand left field. And we filed suit, and I did on behalf of the city of Fort Worth in Tarrant County. And we were able to hold venue here. But eventually, what happened is that we got in the Supreme Court on the venue challenge. And Dallas took the position that it ought to be in Dallas, but it certainly shouldn't be in Fort Worth because that was going to be a horrible thing. D. Kelly represented American Airlines. I represented the city, and it was my appeal. And so D wanted to make the argument, and I can do a pretty good imitation of him. I'm not going to do it here, but in the event, we go down to the argument. He wanted some time. He wanted some of my time to make his arguments. I thought that was fine. But I agreed that what I would do he wanted me to give it to him up front, but I'd never get up to talk. He'd go on and on. And instead, I said, I'll leave you 5 minutes at the end, and I promise you I'll leave you 5 minutes. And we got into the argument. The lawyer for the other side, for the city of Dallas, stood up and looked at the court and says, venue, we all know, is outcome determinative. Basically saying that where you tried the case was going to decide how it came out. And Kelly went nuts. And he's sitting to my left. And he looks at me and he says, they can't say that. Can they say that? They can't say that. And I'm thinking, oh my God, this is horrible. The 9 members of the Supreme Court are right down looking at us, and I look up and realize they are no longer listening to the Dallas lawyer. They're listening to Mr. Kelly. And they're smiling, and they tend to agree with him. And I'm thinking, okay, lesson learned. When she finished her argument, I got up to talk, and I put my hands on the table, and my left hand was next to Mr. Kelly. And he was trying to tell me something, and Jody, as you know, I'm deaf in this ear. And I couldn't understand him. I was turning my head, and he grabbed my hand and then wrote what he wanted to on my hand. So I'm going up to the podium trying to look at it and see what in the heck is D. Kelly written. And I get up to the podium, and Tom Phillips was still the Chief Justice, and I went up and I said, may it please the court, the issue in this case, and as far as I got, and Phillips said, oh, no, we want to know what Mr. Kelly said. So I'm trying to say, and I'm looking at it because I don't want him to get up, but I was too late. He popped up and made his point and got his presentation up front regardless, Jody. But what a remarkable man. I miss him terribly.
You've kind of answered this, but how's the practice of law changed during your career?
It dramatically. For the longest period of time, we saw changes in science and medicine, for example, that did not translate themselves into the practice of law. We had huge developments in medicine that made operations and other things more simple, but we didn't see anything. We tried lawsuits the same way. What changed us dramatically, and I could go into Selectrix typewriters to Magcard typewriters to computers and the like. But what really changed the law was online research, online availability of information. A great man once told me that people are not smarter today than they were before. It's just that they get to share ideas and can mold their thoughts on other people's discoveries. That has made all the difference. The information that we now have means that we can be much better lawyers and understand what faces our clients and quicker than you can do otherwise. It's caused us a lot of problems as well. Do jurors look at online things on YouTube and everything else when they're not supposed to in jury trials? We're trying to address that issue now. But I will tell you, as an appellate lawyer, you can find out almost anything about anything online if you have the ability to operate a computer. Really a remarkable change.
What about advice for young lawyers who are just starting out in their practice?
Here's what I think I would tell them, and I hope my son is one of these. Practice of law is a great profession. It really is. We lawyers really do help regulate people's disagreements. In other parts of the world, people go to war, kill each other, have physical battles rather to settle their disputes. In this country and a lot of the Western world, we're way over that and don't do it. The dispute resolution process that law brings is truly remarkable. The ordering of society is remarkable. It is an honorable profession, and know that. But your part is to be honorable too. Be truthful, and not only with the other side in courts, but with clients. So often one of the things I find that distresses me is that a client did not understand the limitations on their ability to recover or something else. And their expectations were raised because the lawyer didn't want to tell them the bad stuff. Part of being a lawyer, and it's difficult for me to tell people bad things. The one thing I've been able to do is when I put my lawyer's mask on, I'm able to do that. And I think telling your client the truth of what's possible and what's not is probably the most important thing you will do. The other thing is, law can be used to effect good change. And part of what we all ought to do is take some time out away from billable hours on a pro bono basis to make other people's life better through the law.
And then what about anybody who's aspiring to be a judge? Anything you have to offer them advice-wise?
Play it straight. The real truth of the matter is judges get into trouble primarily because they let their personal ideas get involved with judging the case. That you cannot do that. You have to be above the fray. You have to not have an interest in the outcome. That is hard to do. Sometimes the very best lawyers don't make the best judges because they're such good advocates, they end up wanting to advocate for one side rather than the other. And that all has to be put aside. And if you don't do that, the people or entities in front of you, the parties, do not get a fair shake, and that's tragic.
Well, David, thank you for coming and being interviewed, and we sure appreciate your time.
Sorry for talking so long.
That's okay. That's why we're here.
All right. Thank you.
Thank you.